is on the, oops, Mallory, did I lose part of it?
No, you're good.
Okay, but if you're here to comment on something that is actually on the agenda, we'll take those comments as the agenda unfolds here. So are there anybody comments not related to agenda items or general comments?
Whitney Freiberg has her hand up, so I can make her public if you'd like.
Yeah, fine, we can do that. I know she's here to ask for a joint meeting, but let's hear what she has
Okay.
to say.
Can you hear me now?
Yes, Whitney, hi, welcome.
Hi there. Yep, I was just putting my hand up because I didn't think that y'all could hear me before. Yeah, I just have a couple of comments regarding the 30-day minimum, so we can wait for that.
Oh, okay. Are you willing to sit around for a little while? That would be good, because that's a big item to take out of order, and I do have other people here. And we probably will, I know that's an item of discussion, so for the uninformed public out there, we have one of our agenda items tonight is an accessory apartment, actually it's accessory dwelling.
ADU. Yeah, accessory dwelling unit.
Which is different. And anyway, so her comments relate to that, and Whitney Freiberg is chair of the Economic Development Committee. All right, so we have, I want to start with a set of minutes. We're really lucky to have a set of minutes. We're quite far behind on minutes. So this is a set of minutes I hope everybody's had a chance to read very recently from our December 16th meeting. Have you had a chance to read it as board members? And if so, can somebody make a motion to approve them? And then we can discuss it.
Madam Chair, there's some errors that I think we need to correct. I'm going to try to bring this up, and maybe after that, with corrections, we can accept them.
Okay, I mean, usually you make the motion and then you make the corrections. You want to make a motion?
Sure, I can make the motion that we, at this point in time, not only review, but approve these minutes. And if we can have a second, then we can have a discussion.
Okay, is there a second?
Second.
Okay, we got a second. So Francois, lead us off with the corrections.
So I believe, let me see here. There is these are just typographical ones. On the second, I think it's the second page. Let me double check. No, I'm sorry, it's the third page, the second bullet item. It's actually on the accessory apartments bylaw it says pre-place. I think it actually means replace.
Yes.
Okay.
Mallory, you've got that? Okay.
Yeah, I'm writing them down.
I'm sorry?
Oh, go ahead. I was just told Alice I was writing them down.
Good. Yep. And at the very end of that sentence, it actually says we can do this via PowerPoint, public forum, getting on social media, on the website, ECT. I think that's ETC, right? Etc.
Yes, I think it is. Mallory, jump in if you have any objection. Anything else?
The first bullet item, and these are just typing errors. I just want to make sure that these are as clear as possible. It says the rate of development of affordable dwelling units revised by law. Alice stated that we heard back. I think we need to indicate instead of the.
Okay.
Next line, it says this updated by oh, it's okay. I'm sorry. I think it says the updated bylaw, and I think bylaw just needs to be put together as one word because it is.
Okay.
Let's see what schedule a public hearing. Yep, that is it on my end at this point in time. Okay. But I just want to get these clearly established in here. I would greatly appreciate if they be made. Okay, thank you.
So we can accept those changes as a friendly amendment. Does anybody else have corrections, additions? Hearing none, ready to vote on accepting the bylaws as amended. Lived all aye.
Steiger aye.
Go in order so she can pick them up. So lived all aye. I mean.
Steiger aye.
Yep.
Monroe aye.
D'Amelia aye.
Great. Thank you, gentlemen. That's fine. On to the next, the first real item of business here, which is, this says it's a special permit application, but it's kind of a special permit application that we decided wasn't complete. So I just want to point that out. So the clock isn't running on that. They want to amend it and we're going to change it and they're going to supplement it. And we're going to start the clock at that point if we can reach an agreement. So this is, but the idea had been presented to us. It's the applicants are Nicole and Gregory Fisher, and they've submitted a special permit application to build a country club at 28 George Howard Road. And they presented that plan to us. And now they've revised their business plan to try to support their claim of a country club. And because they have some new ideas of what they want to do. And I also want to tell both Nicole and Gregory that Jeff Blake is here. He's town council from KP Law. And I told him to stop writing his opinion because the business plan had obviously changed. And he hadn't gotten much of a start on it, I don't think, maybe a little. And then I sent him your new business plan, but then I invited him to come and listen to you tonight. So he doesn't have an opinion tonight ready, but he's interested in what you have to say as well as the rest of us. So I know there was a handout. We did, they did email in their new description of what they want to do, which again, it was posted and Mr. Blake has a copy of, but you can start from wherever you want to start.
Nicole,
Sure.
before you start, did you have anyone else with you that I should let in to talk?
Greg, I think, is on the phone, but he will be able to join probably for the next couple minutes.
Okay, no worries. Perfect. Thank you.
Sure. So
One second. Sorry to interrupt, Nicole. Madam Chair, the matter of standing, has that been addressed?
I think it has been, but we have town council right here and we can ask him.
Okay.
So Mr. Blake, are you there? Can you?
I am. Yep, I'm
Okay,
here.
so the question came up, and I should just say I'm a retired lawyer, and so it's kind of a familiar question to me. And also Christopher Monroe on our board is also, and we both believe that the answer to the question is yes, but we will ask you the question, which is if somebody wants to purchase a property, so do they have a right as a potential buyer of that property to file an application for a special permit if they have the permission of the owner?
Yes, in fact, that's very, very, very common. Oftentimes you'll see a purchase and sale agreement that will be contingent upon getting XYZ permits, and the potential buyer will go through all of the hoops and try to get a permit. If they can't get a permit, then they don't purchase the property. So yes.
So may I address Attorney Blake?
Yes,
Absolutely.
go ahead.
I do have some additional questions, and that is so you brought up a very important point, and that is that it is with a purchase and sale agreement in place. I think the question at this point in time to the applicant, is that indeed in place? We just want to make sure that we're covering our bases here and protecting the board from doing something that is absolutely incorrect. I just want to make sure, please understand, we're not opposed
yeah,
to this.
no, it's totally fine. So we have put in an offer. We are in negotiations right now. Our intention is that once the offer is accepted and that both parties agree, we will have a P&S, a purchase and sale. And in that purchase and sale, just like Mr. Blake said, it will be contingent on certain factors. One of them being, of course, a special, permit being granted. That's, as he mentioned, very common. And we do have permission from the owner to be even talking about these things with you and moving forward with, asking for a special permit, et cetera.
And Mr. Blake, I just want to make sure on a technicality here, since the purchase and sale has not yet been executed, how does that make this? I mean, if obviously we're discussing this here, I don't think the application has come in yet. What are we saying that a special permit does require a P&S to be in place?
No, that's not. No, I'm saying that that's oftentimes what you see in a P&S. But no, I believe that these folks could request a special permit with the assent of the landowner. So I don't see a standing problem with what I know is going on right now.
Appreciate your input here. We just want to make sure we're protecting the board here. Thank you.
Yep.
Yeah, actually, thanks. So I'm going to give the floor to, so to speak, the screen maybe, to Nicole Fisher.
Okay, thanks. So I think everybody has reviewed the document. So I think probably for a matter of time, because I know you had mentioned that there's a lot in the agenda. I'm just going to give a brief summary, and then if there's any questions. But I just wanted to clarify that as per our discussion last meeting, we had talked about how we weren't obviously moving forward with this special permit application until we had reached an agreement on our definition. As in, moving forward with a special permit application requires a hefty investment from us to be able to do everything that's required in land surveys, etc. So we wanted to take the first step, which was to determine the definition and have the board be in agreement with us about a definition, so that then we could take that next step. So this piece that we submitted is specifically towards speaking towards the definition, in other words, not necessarily a special permit application. I just want to make sure that's clear. And Alice, I believe you had said that was okay.
Yeah, so, right, so I had them submit, the problem is involving town council. I thought we needed this guidance, and rather than just working from, you're just coming in off the street and saying, we're interested in this property, can we do this? I wanted you to put something before the board, right? Which you did, which was an initial special permit application, which we didn't accept as complete, but it was enough to know that you're serious and this is what you want to do. And it included a written explanation of exactly what you wanted to do, so that we could get a tailored opinion. We could get an opinion from town council. So the question is now, though, you've changed those activities. So what I've asked town council to do through the town administrator is to give us an opinion whether whether the kind of activities you're describing would fit within the definition
Of a country club.
Because our bylaws don't
Have a definition.
So it would be probably a broad definition of a country club, but at least would fit, right?
So yeah, I appreciate that clarification. So to summarize, what we have here is what we are looking to do is to create a country club that people will pay an annual fee to be a part of. The annual fee we felt was best to be sort of seen as like a family fee, where it could be up to 4 people, and then there'd be an additional fee for additional parties in that group. And there would be a pool that would be common use. There would be a venue space that would be common use. We would provide quarterly social functions, which would include meals, etc., for all the members. And then in addition to that, there would be weekly or monthly social and active experiences that would be part of the membership. And we gave various examples of what that would be, such as, being able to have guided nature walks with ornithologists in the area whom we already have relationships with, yoga, archery, mountain biking, night experiences with astronomers, horseback riding, canoeing and kayaking, cross-country skiing, etc. So as you can imagine, these would be organized activities that would be posted, members could join. And really the big part of what we want to do here is we're not looking to create a country club with a golf course. We really love this land, A, because it's protected, and B, because it is so special to have this huge chunk of land in, Massachusetts, if not the US. And so to be able to totally destroy that and put in a golf course, we didn't feel was the best practice. We wanted to, savor the land and be able to offer it to our members as a way to have these wonderful activities, to enjoy the land. So that's kind of our intention with how we would utilize it. People would have the ability to also rent out the facility to host their own private events as well if they're members. And that could be anything from, birthday parties to a wedding to a special corporate event, whatever they see fit.
Okay, but you would also allow non-members to rent the facility, which is commonly done in golf courses. You're not
Yeah, Greg and I actually talked a lot about this, and I think our initial gut reaction was we could rent it out to anyone. But I think how we're starting to see this is if somebody wanted to have their event there, they would have to become a member first. And I think just from a legal standpoint, it makes more sense that way from a liability standpoint. It also makes more sense that they would have to become a member to be able to hold an event there.
Okay. I'm gonna let other members of the board ask questions. I know Christopher has questions, but one question I do have is, have you explored with which of these uses you're proposing? So I guess I need to tell Mr. Blake, I've sort of explained that about 2/3 of this property is watershed protection and DCR land, for which the development rights have been sold, but the underlying title remains part of, in the owner of 28 George Howard Road. So the question is, though, uses you can use a watershed protection land for are quite restricted. Are these on those lists? Have you taken a look at any of those?
Are you asking me or are you asking Mr. Blake?
I'm asking you.
Okay, yes, we have. So we did look at those and we saw that, for example, on the lake, there can't be motor boat activities. So that's why we specifically mentioned canoeing and kayaking. We know that there can't be a group of more than 25 people, which we would never intend anyway. The whole point is to be able to enjoy the natural surroundings and not be with a huge group of people anyway. Who wants that? So we would have actual caps on, if a lot of people wanted to sign up to be with an ornithologist, it would only be for maybe 20 people or 15 people. So we did take a look at that to see sort of what our stipulations would be and our what is possible on the land. We also know that there are 100 acres that are not restricted at all, that are outside. So certainly that's free reign. And we also realize, that could be where like a lot of cross country skiing or other bigger activities would take place, and certainly where the pool would be put in. So that was important to us to look at that list too.
Okay, thanks. I'm going to let some other people, including Mr. Blake, ask some questions, but I'm going to ask Christopher. He wrote a really great list of questions. Is he there?
Yes, I am.
Okay.
So having some more time to kind of sit with this and think about it, I know I've become less concerned with the idea with the bar of a country club itself, but there potentially being an issue with the underlying idea of a club, because for it to be a country club, yeah, there's the dictionary definition. It's a club organized for social recreation purposes, but we still have to get by that first bar of club. And clubs, they tend to be organized differently. They're not necessarily for-profit businesses. They're usually organized for a particular purpose. So that's something that I think we would need to look at, and that's also something that I would hope council would look at, on whether or not that's going to be a hurdle that we need to look at in terms of the usage itself. Because like and to jump ahead a little bit, I looked at a couple of cases where this came up and this was an issue, and people came back from the community and raised complaints saying, well, this isn't really a swim club. It's a for-profit entity. So the analysis that got walked through in those cases were, well, is it for-profit? Is it organized under Chapter 180? How does membership work? Is there a membership committee? Does it have a board of directors? There were like all of these kinds of things that I think might attach if you're talking about having it be organized as a club. But I would defer to Attorney Blake on whether that does in this particular situation. I did want to bring those up as a point to make sure they get into the analysis.
I reviewed the letter that was sent out, that was sent to me, that is essentially exactly what Ms. Wineland Thompson has indicated what their use of the property would be. Country clubs are not defined in your bylaw, as we all know. Typically, if you don't find a definition in a bylaw, you would go to a dictionary, and there's case law out there that says what the common use or common understanding of that particular term is in the area. So, that's something that the board's going to have to grapple with. I don't know that there is a common understanding in the area of a country club. When I think of country club, I of course think of a golf course. But the definition does encompass more than that. and you do appear to be providing a membership for a social club, a pool, the like. I think one of the biggest problems that we have in trying to give you a yay or nay on the definition is that you've given us something that is almost aspirational. You've given us, okay, this is what we're thinking about doing, but the devil's always in the details. And I understand what you're saying. I understand that you don't want to plunk down 10, 20, 30,000 bucks only for a town to say, sorry, you can't. But at the same time, we get in a position where, if you're having a membership club and you're offering these type of activities, it likely falls within the definition. But until you can show us exactly what you're doing, where the trails are, where the buildings are, how much parking, a lot of the other stuff that has to go into a special permit analysis, it's going to be difficult.
Yeah,
So,
sorry.
Madam Chair, if I
Right.
can ask a question.
Yeah.
Attorney Blake, so do you think it's fair to say that the definition of a club or of a membership club would be included within the definition of a country club, and that would be a hurdle to clear before you even started talking about it being a country club?
You mean that it would be a hurdle?
Yeah, so
Well, I
it would
guess-
be a requirement for something to be a country club, that the underlying organization or entity would need to be a club before it could be a country club.
The definition is that private country club is a membership organization for golf, recreation, and social activities. And the other one is a club with sporting and social facilities set in an urban setting. Now, if I understand you correctly, you're asking me, does it need to be a club? And I think it does. I think it does. But I also believe from the list of the letter that was sent out that it is going to be, there's going to be a membership model would be similar to that of a typical country club golf club found in and around Boston area, where we charge an annual membership fee. This fee will be $3,000 per year for up to 4 members within one party, et cetera, et cetera. So in my review of it, I think they've gotten over that hurdle. They are going to have a club. It's not going to be a just come here and pay 50 bucks anybody and walk in and use the skiing or the like.
It can be in private ownership, a country club.
Yes.
So it could be a private corporation. It could be a standard business corporation, which is probably they would incorporate, would be my guess. Yes. Okay.
There may be tax reasons why they might do nonprofit, but I don't know if this would even qualify. But yes.
It doesn't have to be a corporation where, you've actually got a board of directors that includes members and so forth. The members can be outside the corporate structure. Do you know what I'm saying?
I do know. I know exactly what you're saying. I tried a case, and it was an appellate tax board case, and I had a similar issue going on, but they are different. But here, we are looking at a definition, and we are trying to take a general definition contained in a dictionary and applying it here. And I think the common usage of club is that it has a membership basis, and that is that you pay to belong to this thing. You typically on an annual basis. And I think, at least from what I've seen, they have provided that is the model that they're looking to go for. She says right in there, a golf course, a golf club is the same kind of model. And I think that golf clubs fall within, a country club.
Okay, that's very helpful. So we could say to her, if they're deriving their revenue, at least a substantial part of their revenue through membership fees, and they can have use fees, like event fees as well, but most of their revenue through membership fees. And they organize it as a corporation, but they remain the only shareholders of that corporation. That's a legitimate, that fits within the corners of what would be a country club.
Again, it's a definition that doesn't go deep into corporate structure and the like. And, unfortunately, our bylaw doesn't either.
Okay.
But I think it would, as long as it has that structure of, you're not open to just anybody. You are limited to people that are a member of this club.
Okay.
And I also think that in part of our analysis also has to be, and we'd like to know how many private functions or functions you tend to have per year, because at some point, does the functions just assume everything and it's really just a function hall?
Yeah, that's a really great question, and actually something that we've talked a lot about as well. And in our special permit application, that would definitely be a section where we want to elaborate more on that thinking, as well as being able to show the floor plan, which we have submitted already, but we would submit that more formally with a site plan review done and a survey, et cetera, because that is important to us, that the use of the facility of the country club remains within the definition of a country club, with the added bonus of being able to have events on the side. Because you're right, otherwise then the definition is meet at that point.
Right. The exception, it assumes it becomes the rule.
Quick question, if I may. Is this, the property itself is not intended to be subdivided into a country club portion and a residence for you, or is it?
No, we have no intention of subdivision at all.
No, subdivisioning just and I'm not saying that you will create a subdivision for sale, but rather that you will divide it into a residential piece that you will be residing in, and then a separate section, which is where you're going to have the country club.
No, that is correct. We will not. Our intention is to remain here in Watertown, Massachusetts, where our residence is, and this would not be a residence for us.
Okay, so this would be solely a country club.
Correct.
I see.
Okay, we really have a big agenda tonight, and everything's important. This is important. I'm not.
Yeah, no.
I'm just trying to figure out from here, I personally think her request is reasonable, that that we could decide ahead of time that what she's proposing, you can put whatever caveats in you want, would qualify as a country club, so that when she invests the next 20,000 in putting it together, we don't pull the rug from under her, unless those caveats aren't met in some way.
Exactly.
So is there a way, this is, I guess, maybe for Mr. Blake, how would you suggest the board do that? We could wait for your opinion, where you list some of these indicia that we've talked about tonight, and say, assuming that her business plan, and it also includes, these basic indicia of a country club, it would qualify? Or is it something where, based on what we've talked about tonight, we could vote? Or how would you suggest, as the chair of this board, I proceed on this?
Well, I think at this point, you probably don't vote on it. You let me draft an opinion. In my opinion, we'll say very similar to what we've talked about tonight. That, based on the information that you've provided, it would appear to meet the definition of a country club, provided, that X, Y, and Z, and I've been taking notes that we've been talking about. And with that in hand, you'd have a legal opinion, and then the applicant, you can share the legal opinion with the applicant, and the applicant can go forward on that. Now, of course, in my opinion, it is going to say that, while the broad general terms that you've outlined would appear to meet the definition of a country club, that as the application is fleshed out and becomes more detailed, there may be an instance, or there may be certain activities that they're going to propose that don't meet, that we feel don't meet the definition. And we, of course, in a special permit, can put on conditions. I did notice that there was a skeet shooting. closer to Boston, that might be a big deal with guns going off. Out in Hubbardston, I don't know if it's a big deal. You know, little things like that. You know, you may want to say, you know, there's no skeet shooting allowed, or skeet shooting shall only be done on, you know, pick a time. You know, that kind of stuff. But I think that once I issue the opinion, you can share it with the other side, and she should have at least some comfort in knowing, provided, of course, you guys agree with it, and I think you do. She should have some comfort in knowing that, you know, as long as she sticks along this path, that you are going to consider it a country club, and you're going to consider her application on its merits.
Okay, so you could put this together, and assuming
Okay.
we agree, we could vote to accept town council's opinion and let her proceed with a special permit application. And
Yeah,
Yes?
I mean, I think that would work. I think
okay,
that would
all right.
work. You know, it just, you saw me hesitate a little bit because I always hesitate to give advisory opinions. However, in this instance, I fully understand where we're at and why we would give an advisory opinion. I don't know that you have to vote it, but at the same time, it wouldn't hurt certainly to put it before your membership one more time. Once it's in writing, we send it out. You've got 2 or 3 or 5 or whatever days for everybody to look it over. And you know, they might want to tweak it too. They might say, well, you know, I think that, you know, X or Y. And that way, at least this applicant will get a very good understanding of where the board is at.
Okay, all right. So we have, our next meeting is the 20th. Do you think you can get to us by the 20th?
Today's the 6th, yeah, 2 weeks, yep. I can do
Okay.
it.
All right, so I don't think we have to take any action here tonight. We do have really a full agenda. Is there anything anybody else wants to add to that? We've got a plan. Okay, all right. Well, thank you very much for all attending. We'll look for your decision.
Thank you.
Okay.
I'm gonna head out, but thank you again.
Thank you, Nicole, for coming tonight. Okay.
Sure.
And
Happy New Year, everybody.
Thank you very much.
New Year.
Thanks
All
for
right,
coming. It was
we'll
very
see ya.
We'll see ya. Bye-bye. Okay. Is Bill Murray with us, Mallory?
Yes.
I am.
He is. Okay. All right. So I'm thinking this agenda was, you know, we kept adding things to sort of where you could pigeonhole them in, and then things got out of order. But I'm thinking that maybe before we might take on the bylaws, before we take those on, we could take on these 2 other smaller matters that are further down the agenda. One is 10. This came back late, but it was discussed. The story behind this is the lot that was being divided on Halfrey Road that had frontage on both Halfrey and frontage on 68. And we declined to endorse the A&R plan because we could not determine, this was just for the last meeting, we could not determine that the guardrail didn't block the entire frontage on 68. So one of the things we can do tonight, and Bill's here because he's very important to advise us on this, is there was, you can see it in the documents, a supplementary site plan prepared by actually a different surveyor that actually outlines both where the guardrail is, where the wetlands are, and where the proposed driveway would be, all the things that Bill asked him to show to prove that if we approve this lot, they would actually have access so they could build the lot, right? So this person has done that. And then there was also always the procedural element. So what Bill tells me is, and he can speak for himself, but he said with this site plan added, he does prove his case that there is access. It's right at the end of the guardrail. Sufficiently that we could now endorse the plan. And what we would do with this site plan, it doesn't actually get recorded, but it gets kept with the town copy of the A&R plan. Is that right, Bill? Am I summarizing that?
It's evidentiary.
Okay, so we could, in your opinion, take a vote tonight to improve that A&R plan based on the supplementary site plan that was submitted.
Yes.
Okay, and then to the board members, obviously, if we take that vote, we're all gonna, either I'm gonna have to trot it around in my Prius to everybody, or you're gonna have to stop at the town hall and sign it because we're remote for the duration until this horrible peak declines. But are there questions for Bill about doing that? Because I'd like to vote to approve it.
Alice, Mark is here if you have any questions for him.
I'm here. I don't know if you can hear me.
Yeah, we can hear you, Mark. Anything you'd like to say on this?
Nope.
Am I summarizing it correctly?
Yes, everything seems to be in order, so that's good.
Okay, so is there someone on the board that would like to vote to approve the ANR? What was the name of your ANR plan? 60, I can get it from the minutes. Maybe,
Alice,
yeah,
it's the Anr Halfrey Road, Route 68 lot.
okay. Can I have, anyone want to make a motion? What?
Technically speaking, it's lot 41A and 41B.
On Halfrey Road, right?
41A is on Worcester Road and 41B is on Halfrey Road.
Okay, so in making the motion, I usually a chair, you don't make the motion, but somebody would make the motion, they would say, if we can word it right for the minutes, right, they can say so moved. So it would be, the motion would be to approve the ANR plan for lots 41A and 41B as submitted on behalf of, what was the name of the company, the name of the people?
Windridge?
Windridge, right,
Windridge.
Windridge.
Okay.
Just give me the quick, how to word that motion.
WINRIDGE, Windridge Holdings LLC.
Okay. So does someone want to move to approve lots 41A and 41B as shown on a plan submitted by Windridge LLC?
So moved.
Is there a second?
John D'Amelio seconds.
Okay, so it was moved by
Christopher.
and seconded by John. Is there any further discussion? Hearing none, are we ready to vote? Lived all I.
Monroe,
D'Amelio,
aye.
aye.
I'm going to be last today. Steiger, aye.
John, are you there?
Yep, D'Amelio, aye.
Okay, so we voted to approve it. Mallory, is the office open where people can stop in still?
So far it is.
Okay.
We open late on Monday, but we'll be there till 6 o'clock. So we open our doors at noon on Monday. We're there till 6 p.m.
Okay, can people try to stop by and sign on Monday if you have any opportunity to do that? What time do you open?
The doors open at noon.
Noon to 6.
Mhm.
Try to
Madam Chair?
stop by. Yes.
I'm
Madam
going to be
Chair,
traveling Monday and Tuesday.
Okay, so you can't, you're Monday or Tuesday.
you're going to have logistic problems because
Yes.
I cannot do it. Chris is not going to be able to do it in that timeline.
Chris, are
you're
you
still-
available Sunday night at all?
I'm available Sunday. I can pick it up, but I don't know if that solves any problems.
No, I'm
Well, I
heading
can
out
meet-
Sunday morning.
You need a majority of the board to sign. You don't need Mr. Steiger to sign it.
Right.
Okay, so
we
John, are
can
you
still
around this
Wednesday.
weekend? If I
Yep,
could,
I'm around.
and Christopher's around Saturday, and when do you say we're leaving?
Sunday, I'm leaving. So
Saturday.
I'm around Saturday and tomorrow.
I'm around. Mallory, is there some way I could get it tomorrow?
Well, tomorrow's a snowstorm and I'm leaving for New Hampshire.
Oh.
Yeah.
All right, so we're going to go back to the applicant here. How about Wednesday of next week? Mark, is he there?
Yeah, that's fine.
Okay,
Whenever
Alright.
you get it signed, just let me know or have Mallory let me know and I'll stop by to pick it up.
I'll definitely
Right.
let you know as soon as we have it, Mike.
okay, so everybody try to get in there by closing time Wednesday if you can, okay? Or Chris, are you back Wednesday, did you say?
Yes.
Yes, okay. All right, done, the best we can do it. All right, next, and then there is another item that's also old business, but it was on the agenda as a separate item, and that's the Healdville Road Scenic remediation where they cut down all the trees on Heelfield Road and upended the wall. And we sent them an order, what they had to do to remediate it. I was out of town. I wasn't able to drive by and look at it. I had Bill drive by and look at it, and he suggests that the work isn't really quite all done because there's still some high stumps. And while they have like filled the ruts, they haven't leveled the right-of-way area, and it needs to be loamed and seeded as well. Well, I don't want to hold up these people's project until the grass is growing, you know?
The dentists are here at Palace to talk.
Are they
to.
here? But I think maybe you know, those other things should be addressed. So if the dentists are here, and Bill is here, let's take that issue next. You can let them come in and speak, Mallory.
Yeah, they should
Here,
be good to
Jeff.
speak.
Okay, I'll go first.
Okay,
I went by, I think it was Monday or Tuesday. They have restored the wall, but they used an excavator to do so. So it's more of a kind of what I would call a rubble wall versus a placed wall. I'll admit that in its original fashion, it was not a complete wall, but it is now. So it is a wall in a fashion, and it is a wall in the location where it used to be. When I compare it to the wall that is directly across the street, that's a placed wall. So the quality isn't perfect, but I think that they've done what they said they were going to do. The problem is there are still some stumps, they're even painted nicely, that are in the right of way, and they're way too tall. They didn't get pulled out. And part of the requirement was to make sure we didn't have any hazard. So there are, I think, 3 or 4 stumps that either need to be cut flush or pulled up. The driveway is in the location they said that they would put it in. And as Alice said, some parts of the right of way on the public side of the wall need to be leveled out, because the intent is, you know, if somebody pulls off the edge of the road, they're not going to drive it into a rut or create a problem and pull themselves into the wall. So I still think that they need to do a little bit more TLC along their entire frontage. But bottom line, in my opinion, is they have substantially met the requirements of the planning board, and cutting down the remaining stumps could be pretty easily done without heavy equipment.
okay, let's hear from the dentists if they're here.
You guys are on mute.
Mallory's on mute. Yeah, we don't hear anything. Mallory, are they here?
They were.
Maybe they stepped away.
They stepped
They
away.
got-
Oh, no, they're still here.
Okay, well, let them, hopefully they were here and heard what Bill had to say. Do they want to
Can you
tell us?
guys hear me now?
There
Yes.
she is.
thank you.
Okay, sorry, this is another computer. As far as when Bill was there, I'm fine with that. Now, the wall never actually looked like the one across the street, I'll tell you that much right now. That's why when we had that meeting, I discussed that I was going to repair it, and you guys wanted me to place it the way it originally was. So that's why I placed it the way it was. That's why it doesn't look like the one across the street, obviously. I did mention to Chris, who cut the other stumps, about the ones in the roadway, and he thought my builder wanted them left there, so we will, before the next meeting on the 20th, those should be done and out, because I talked to the builder today. As far as the ruts, that, what do you want to say, right away or whatever, was never level to begin with. It was extremely bumpy and ruddy, and it's just been left for so long. All the leaves were collected in the debris and everything else. I mean, I personally do not like the look of it either. So I was thinking, like, when we go to landscape, I'll make it look better, because right now I don't even know what I could get into in that area, because it just looks like, I know that they started moving some stuff and we're getting into rocks. So that's why we just stopped right there. I mean, you could start making a big rock pile. So,
So generally, we don't have people landscape the, it's supposed to be a kind of a natural look.
right.
But if in replacing the wall, then pulling the trees over it and so forth, it now slopes up towards the wall and where it should be really kind of flat.
Mhm.
Thing, you maybe could get an excavator in there because you probably can't. I agree, there are probably rocks embedded in the soil.
Yeah.
But if you could pull it back to level it out as much as you can, just have somebody go through it with a rake and a hoe, would that work? I know leaves are an
I
issue.
can personally do it myself. You know what I mean? I was up there over the weekend and I did fill in a big rut that was by the roadside, which was obviously left from one of the contractors, just left the rut there. So I fixed that in case someone hit it, whatever. I mean, I don't have a problem doing that, but when I was in there baking, there was like so much stuff in there, you can't even see like what you have to really work with. I know what you're saying. I'm gonna leave it natural. Like I'm not gonna like landscape and put all grass in and pedicure or whatever. But I mean, I don't really know what is actually there until you start, like you said, get a leaf and get all that stuff picked up. It's just like debris that's been in there and trees that have been thrown in there, like brush. It's just like a pit, I think.
Well, Bill, what would you suggest? What should she do? Should we ask her to, I mean, this is one of those situations where if it hadn't been disturbed at all, it could probably be left the way it was, but now it has been disturbed. What would be good? Maybe to have a crew come in, take the leaves out, see where the land stands and level it out just in the rough places. What do you think?
I just want to make it, if for some reason you pull off the edge of the road unexpectedly, your car isn't going to keep going towards the stone wall because it's been caught into a rut. I just want, like any other part of any other road, you want the edge of the road to be safe. And since I live on Healdville Road, if the board would accept it, I would meet the applicant on site and point out the areas that I'm worried about.
How about that, Nancy? Because
No, I totally agree with that, because that way we can make sure that all the trees that you guys wanted cut get done. I mean, I don't know if I can do the right away like right now, because you figure with the snow coming, and then things gonna start freezing up pretty soon where you can't really work with it. If I could just talk to Bill and then we can go from there, we'll know exactly what needs to be done. So that way I can start moving forward with the permits, because I know my builder is getting anxious about that.
Yeah. Okay, so why don't we do this? Nancy and Bill will meet. You'll come up with a list of the specific things. And Bill's very good at writing this stuff up through a drawing or whatever. So he knows what it is, because he'll be the one that goes out. And then if it is stuff that cannot be done till spring, we would release you for the permits. We would release you to go get the permits on the understanding that the work will be done by
Good
May
faith.
1st or something. Is
Yeah,
that all right?
yeah, that's fine with me, because I mean, I'll work with you guys in good faith. I mean, I'm
Okay.
not want to
Madam
look
Chair?
at it is either.
I think you're at that point now. I think that you can release the permit with the understanding that the minor things can be done in the spring. And I totally agree with Ms. Dennis that what we're asking for should probably wait until the spring.
Okay, so if we had a vote tonight to say, we would we release the hold on the property for permit for, the holding of the permits, and allow her to proceed, provided that the work agreed upon between you and her is done sometime in the spring.
Yep. And of course, if she thinks I'm being unreasonable, she can take it back. She can appeal to you.
Okay.
But not too many people have called me unreasonable.
Okay, so, all right, so does someone want to take a stab at a motion to that effect?
Yeah.
Everybody's like, what? All right, motion. Okay, I'll see if I can do it and then somebody can do so moved. All right, so with respect to the Okay, so the motion would be to recognize that that Nancy and Jeff Dennis of 4 Healdville Road have substantially complied with our order to restore the right of way. And we will therefore allow them to proceed with construction on the understanding that they will finish the work in the spring, agreed to between Places Associates and the Dennises.
So moved, Francis Steiger.
Okay, is there a second?
Second.
Okay, any further discussion? Hearing none, let's vote. Lived all eye.
Steiger, aye.
Demalia, aye.
Monroe, I.
Okay, so there you go. So Mallory, you have to write that up as a vote.
Yep.
And then you have to send a vote, send a copy of that vote to
Everyone.
Nancy and Jeff, and if you need to get it to the building people,
Yeah.
you're right
I
there.
got it. Absolutely.
Good, okay, resolved.
Okay, just so I can say one thing, Bill, do you want me to just get a hold of you by email? Because I do have your email address.
Sure, or you can do it through Mallory if you want a phone call.
Okay, well, whatever you'd prefer, it doesn't matter.
I respond many different ways.
Okay. Thank you.
Thank
Good night.
you. Good night.
Good night.
Okay. All right, do we still have Whitney?
We
Listen?
do. Yep.
We do. Okay, so then my suggestion is that before we do the battery storage, she's here for 2 things. She's here to comment on the accessory dwelling unit bylaw. So can we take that next out of order? And also, just because she's waiting, and also ask her, she has written me a letter, it's in correspondence, that, and also Christopher's involved in this, that they want to have a joint meeting with the planning board to really try to get down to this farm use, accessory use bylaw. I think, right? Is that what you want? Why don't you put Whitney on?
When you have to take yourself off mute.
Wait, she wrote to me, she said,
Yeah.
Hi Whitney. So her note to me, the board said, on January, the EDC meeting is on Wednesday, January 19th at 6:30. And then the next meeting will be Wednesday, February 16th. So we could meet at one of their meetings. We could just go as the guest, or she could come to one of ours. But our next meeting, and we can't really put you first at the next meeting, because the next meeting involves a hearing on a bylaw that's been publicized for 6:30. So
Sure.
I'm happy to go January night. It would be the night before, but I don't know how many other people are available on a Wednesday night to come to the planning board. What do you think, board members?
I think it's worth noting it's pretty likely that that's probably going to also end up a virtual meeting, if we're talking about one that's 2 weeks away. Although
Yeah,
it could be in person, we don't know.
I did put that in the email, and I said until further notice that all of our meetings are going to be virtual. And I thought that would actually be, enable more people to attend as well from planning board.
Well, I can come. Who else can come? Christopher sounds like can do a
Yes.
Wednesday night.
Can you give me the date? I'm sorry, Madam Chair. Can you give us the date again?
Christopher's he's our liaison. I mean, he's one of our members, actually. He's a voting member, so he'll be there.
Right. Can you put us first? Bill, Francois wants to know, or if you're
Sure,
gonna
I
come-
put that, I
No,
did,
no.
I put that in the email as well. I said I could have you I could have a joint meeting listed at 6:30.
And
Okay.
can you give us the exact date again? I'm just pulled up my
January
calendar.
19th, January 19th, right?
Yes, yes, the day before yours. Because to wait to go to yours, we wouldn't have another meeting till February. That's almost 30 days. There's a lot that can be done in those 30 days. So
Right.
I'd rather, I just thought it would be a better idea to, maybe have it at our meeting, and then for the next 30 days, we could be working on it, rather
Well-
than wait for the next meeting.
Well, we
Madam-
need 3 of us to show up to have a quorum, and then it's got to get posted to meet with you. So I can
Correct.
come, Christopher can come, Francois can come, John can.
No,
you
no,
come?
no, I'm sorry, Madam Chair. I can only do a tentative at this point in time. We're in the process of wrapping up the remodeling, and I need the afternoon sometimes to be able to get out there. I can put a tentative because it is at 3:30, but it is only tentative at this point in time. I apologize.
Oh, your obligation is 3:30. Okay, this is 6:30. Okay.
No, I'm sorry. You got to think of it.
Pacific.
I'm sorry. It's 3:30
Oh.
Pacific time.
I'm sorry. Yeah, stupid me. I'm sorry. Yeah,
No,
yeah, yeah.
no.
Forget you're not like across town. Okay. All right. How about John? John, can you do a 6:30 meeting on the 19th?
If it's virtual, yes.
Yes. Okay. So we will do that. And Mallory, will you ask Bill will you send a note to Bill?
Yeah,
Our
of
members
course.
that's absent. And Erica, if you can come, that'd be great. You're welcome to. And then Mallory, you have to post it and send reminders to us all. Okay. And do we?
So
have
as of now, Alice, you have quorum as of now?
Good. Yep.
Okay, fine. So I could go ahead and set the agenda and send it to Lori, because I'm not sure if the 17th is a holiday.
It is.
It is.
Okay, yeah, and so we have, I need it, a good period of time before the set meeting. So I'd
Yeah,
like it to be posted by next Wednesday if possible.
Also, the Zoom space is limited, so grab it quick.
Yes,
Yeah, okay.
yes,
Yeah,
but
Whitney-
we do, but one of our committee members does have a Zoom account, and we've done it before. We've used her account, and then she sends it over to Lori.
Is
Video.
that, I'm sorry to interrupt, but is that something that recording is available through that Zoom account?
Yes,
Okay.
Okay.
Yep.
All right, so,
as long as she hits the button.
well, we'll try to get the town to do it, see if there's somebody.
Sure,
But-
sure.
Okay, so you're going to arrange it all. Do you have homework for us? Whitney? Yeah.
Well,
Do you-
well, I did send, Christopher, because again, he's one of our members, some of, the information about some of the benchmark towns that I looked into, the other ones. Basically, we're working off of Rutland's and a little bit of Bolton's as
Yeah.
well.
Yeah.
I did send emails out quite a long time ago to both the police department, the fire department, wanting their input. I think that needs to be considered as we write this, and haven't heard back from either one of them, but I'll definitely, knock on the door in the next couple of days. But no, I think the intention of this meeting is to, pull everybody together, decide if we need a subcommittee, if we want to involve stakeholders or that kind of thing, or move ahead with, what I think is a pretty good committee of people working on it. So
Okay.
I just, we're just going to work on the next steps. I mean, I don't think it's a bad idea, Alice, to take the template, if you will, from the MRPC, from the Delta grant for the commercial overlay, in terms of how they space things out, their preference or their advice, let's say, to include visual surveys and that kind of thing. I think that we can glean a lot of good information from that little template, and we could go over that at the meeting as well.
Okay.
And
Okay.
just, get a schedule going.
Okay, excellent. All right, we will just come, and you can backtrack and walk it through if you want. And
Okay.
Chris, if you think it really would be helpful for us to reread Rutland or Bolton's, you can post them for us, okay, to read through.
Yeah.
mail. Okay.
I will
Okay.
certainly provide some materials. I've been spending a bunch of time researching this lately.
I know.
And for Rutland, a lot of it really originated out of the Rural 11 program from Central Mass Planning. So I'll grab some materials from that I think are worth both committees looking at, and I'll send that out, or I'll send
Sounds
it to
good.
Mallory to have sent out with the meeting posting.
Yeah.
And
great.
also, I should mention just two things briefly. Number one is that, I've spoken to David George in Rutland Planning Board, and he was obviously instrumental in their bylaw. And he is more than willing to come to one of our meetings to talk about, their ups and downs and their time frame and that kind of thing. So if that's something that we want to consider, we might want to do that sooner than later. Then the other thing is, Bolton and Rutland are, very on one side of the spectrum, each one of them, opposite side. One is much more restrictive, et cetera. But I will say that the benchmark towns that you sent to Jennifer not too long ago, Alice, when I was doing the research on this back in, April and March, I did look at several other towns. They ended up, most of them were part of the benchmark. Those other towns that are considered the benchmark towns, their policies or their bylaws are not, very definitive, and they're all alike. The wording, everything, just absolutely like, copy and paste. Wasn't a lot of detail. And that's one of the reasons why, we looked at Rutland, and then Mallory had sent to Katie, who then sent to me Bolton, which was great. And so we had two that varied in a lot of ways. And I thought that was, good to be able to kind of glean from both of them. But the other benchmark towns didn't offer very much information. That's what I found.
Okay,
So I just
excellent.
want you to know that they were looked into, they were researched.
Great, great. Well, we'll pick up the discussion on the 19th from there. But
Okay.
before you leave,
Yeah.
to the board, and I know I'm making hash out of this agenda, but the board knows that I worked very hard on it over the last few days to really get from a checklist that we worked from to a draft on this accessory dwelling unit bylaw. And then I put it out there, and we're going to talk about it tonight. But there is one issue in it, and that is the issue of we're going to allow them to be, well, I propose in it that we would allow these accessory dwelling units to be rented, and we'll talk more about that in the end. But I said rented for a period of no less than 30 days. And there's been a lot of objection to that from Katie, and I believe that Whitney as well, that say we should not put that on. We should actually allow them to take advantage of the Airbnb type.
Correct.
rental. So,
Correct.
okay. So that's what you're here to say, right? Because we haven't opened that discussion, but it would allow
Yes.
you to make that pitch if you want. And then we've got a lot of other things in that bylaw we need looking at. Okay.
So the first thing I would like just a little bit of clarification, because I brought to Ryan's attention Airbnb and the benefits of short-term rentals in our town back in about 2019, I think it was. And Katie and I went in and met with him after that. And in fact, that day he was on the computer and looking at what some of the other towns, surrounding towns, were charging in the tax that would come to the town. And then he told us, go back to the committee and vote on a percentage that we wanted to charge for that. And so we did that. And then I did ask the committee to, think about that again, look at some of the current listings. I felt that it was too low, and was trying to, get that rate, higher. And brought it back to Ryan, and that was the last that we heard of it. I did have a conversation with Dan at the select board about this back in April of 2021, and spoke with him about what was already actually listed. I mean, we do have people in town who are on these platforms, these short-term rental platforms. And just from the ones that were listed, and we only looked at Airbnb, we've got VRBO, Home Away, and dozens of others. Dan had come to the conclusion that in one round of the listings, we would be able to pay an entire police force. So, aside from that and the stream of income that it would bring to our residents as well as our business owners, we just feel very strongly about being able to implement Airbnb and these short-term rentals in town. And we thought it was ongoing. So I'm because no one ever said to us, there's a decision made, it's not going to, we're not going to pursue it any longer or anything like that. So I'm wondering, how how there's a possibility of implementing a, minimum 30 days, on these ADUs when we have an ongoing project, let's say, that, that we've approached both our town administrator and our select board about.
Okay, so we will discuss that. I think, presently under the bylaws, you have to understand, presently under the bylaws, the only people that can occupy an in-law apartment are direct relatives of the owner of the property. Okay, so we're trying to get away from that because, couples aren't even married these days, right? So
Right.
it should not be a relative. So we're trying to broaden it out.
Sure.
And then the accessory apartments require a special permit now, and that the unit is 5 years old. And so we're trying to bring those into line. So what we're doing wasn't in any way designed to actually to target in on this issue at all, right? It was to try to fix what's wrong with this bylaw, and it's one of the issues that came up. So we can discuss it. The planning board would have no ability to implement a tax. I mean, that's got to be something that's got to, I don't know how you implement a tax, a general bylaw or a policy or.
Well, Katie told me today that Heather Monroe had said something about that if there's any tax implemented, it has to be by town vote.
Okay.
I have never heard of that. And I've been working with Airbnb for private clients for many, many years. And I'd never heard of that. But if, if that's what's necessary, then.
All right. Well, I'm just telling you that there's no way the planning board will get involved in sponsoring that article. But I agree.
I just learned something, but
because we don't have that ability, but we can fix the bylaw that would allow, if that's the will of the board, to present to the voters a dwelling unit bylaw that did not have a minimum period of rental. So we'll talk about that tonight. And we hear you loud and clear. And Katie.
Okay.
And I posted it. So.
Okay. And if anyone, would like more information about these platforms and why we feel, so committed to this and have been so focused on it, I'm happy to discuss that. I mean, there are tremendous benefits. And
okay. Whitney, there will be a public hearing on this bylaw.
Sure.
It probably will be March 24th. Mallory, jot down that she needs to know that, right? If we do it. And I think you absolutely should come to that and speak to those issues, if that's the way you feel. Okay? Because that is to get public input. That's what the public hearings are about. So however we vote tonight to put our draft forward, whether it's with it or without it, it can be changed based on what's said that night, right? Because that's the public hearing. So pencil it in and plan to come. I think it's going to be the 24th. And to the rest of the board, the reason the 24th of February is the fourth Thursday instead of.
You just said March, and now you said February.
February. I'm sorry, February, Whitney.
Okay.
Yeah, because they're pushing to get the warrant done, right? So I need a draft. But to the rest of the board, Mallory is not going to be available the third week in February, the Thursday. So one of the things we also have to discuss tonight is bumping that meeting to the hearing. Get through this tonight to the 24th when she will be back available. So that's why it's tentative, Whitney, but we'll let you know.
Okay, well, can I just ask then, are you suggesting that we are not meant to pursue our, wanting to implement Airbnb? Is this overriding that? Is this?
No, this would only deal with people that have, apartments attached to their house, right? Most Airbnb people are renting their whole house, are they not?
Oh, no, not necessarily. I mean, that's what sets Airbnb apart from the other ones. Airbnb really started as room shares and like that in New York City and other, urban areas. And VRBO was the platform that did the whole house rentals. So Airbnb, does everything. They do it all. And I want to, we all feel very strongly about, this being a great stream of income for residents, businesses, as well as the town. And so I don't, I don't want to lose that. I really don't. I'd like to see if there's some way, I don't know how it would be done, but I don't know. I mean, is there, would it be helpful if we could find a way for that percentage to go to an affordable housing account, if you will? Would that be helpful, to your efforts?
Yeah, I think that you're ahead of us. I think that we as a board need to come to we need to hear what you have to say. But I think the issue is not that we're either in favor or opposed to it. It's just, I had to put something in a draft, right? And this is something we discussed. So it's on the agenda tonight. And we'll make a decision. But it's what I told Katie, is I don't think, my fear is that you allow the rentals, you're going to have a lot of objection, and it may sink the bylaw, which requires a 2/3 vote. Because there might
Okay.
so that's my concern, and we have to balance that against, what other people want and what we're going to do. So we as a board don't know what we're going to put forward at this point, but we might come to a decision tonight, and you're welcome to sit back and listen to the discussion if you want, or we'll take it. So, everybody's heard what you have to say too. So we'll
sorry, guys.
whether you stay or not. No, we want to hear.
Well, I am going to bow out. But before I do, there is one thing on this draft, and I'd like to just, I don't know if, I just like clarification on how it's meant. It says the single family residence and the accessory dwelling unit may not both be rented or leased to tenants on a year-round basis. And then the next sentence, or number 4, is lease or rental of the accessory dwelling unit must be for a term of not less than 30 days. So I don't understand that sentence before. The single family residence and the accessory dwelling unit may not both be rented or leased to tenants on a year-round basis. So if it can't be year-round, but it has to be more than 30 days, what are you defining as the term?
Well, the issue, I'll have to look at how I wrote that. Maybe it's not right away. The issue there was that we had made a decision in our preliminary discussion that the owner needs to occupy, it needs to be an owner occupied house, right? So it's not supposed to be, so somebody can just keep it as a residential property and rent out both sides.
Okay.
It's supposed to be, but then somebody said, well, what happens if you have a situation where you've got the widow and her kids want to move into the big house and she wants to move into the in-law? Because these apartments span generations, right? So that was where the idea came that, yes, the owner, one needs to be owner occupied 5 months a year, but the owner can occupy either the house or the in-law apartment, right? But it would prevent somebody who says, that's their starter house that has an in-law apartment, right? And they decide, we're not going to sell this house. We're just going to rent both units out and have it be an income property.
Okay.
And the idea there is because you can build a two family anywhere in town, but it requires 50 more feet of frontage and more 20,000 more. I don't know what I mean. So we're trying to distinguish it from what would be a 2-family, in which case you could own a 2-family and rent out both sides. Right.
Okay. Right.
So, all right. So let us go through it. We need to go through it.
Yeah.
And but we hear what you have to say.
Well, thank you for hearing me. I appreciate it. And Happy New Year to you all, and have a good weekend. And we'll see some of you in a couple of weeks.
We'll see you on the 19th. Okay.
Thank you so much.
Thanks, Whitney. Bye-bye.
Good night. Bye.
Okay, so let's, since we're kind of up to our knees in this already, let's go to the accessory dwelling unit bylaw, which is number 7 on the agenda. And, this is not a new discussion, but for the sake of the public, I'll say that, and it's on this guide sheet, that what we're trying to do here is replace accessory to the in-law apartment and the accessory apartment with one accessory dwelling unit. And the main changes would be that that in the present in-law apartment, you must be a relative of the single family occupied residence in order to have it. And then the main problem with the accessory apartment is your house has to be at least 5 years old to add one, and you need a special permit to do it. So this is trying to combine them with an eye towards making more housing availability, recognition of our times where people aren't related, recognition of the need for nannies and caretakers. And so anyway, this has been trying to reform that, and it starts with a new definition. So instead of those old definitions, the new definition is at the bottom of we'll go in the definition section of the bylaw, which I kind of derived from the other ones, but see if it works for you guys. It says an accessory dwelling unit, a group of rooms located within or attached to an owner-occupied single-family residence or above a garage of a single-family residence, consisting of a kitchen, bathroom, and bedrooms, plural, which are used as a separate apartment for a limited number of occupants. Occupants may include relatives, dependents, and guests of owners, caregivers, nannies, and other service providers to the owner or tenants. Maybe that should be and tenants. But is there anybody that has a problem with that definition? Oh, yeah, or tenants, right? Because it's a separate category. I mean, if you do and you've marked it up, speak out, otherwise we'll progress. So then you go into the accessory dwelling unit, the article itself, which is the next page. So it picks up from where that ended. The following terms and conditions apply to accessory dwelling units as defined in that section we just read, right? So I used our checklist to put this together. And there are some questions where I couldn't remember what we said and maybe we didn't decide it, but basically walking through it, it's accessory dwellings would be allowed in all zoning districts. Accessory dwelling units are only allowed as part of an owner-occupied single-family residence. Entitled to that accessory unit can't be separated. I mean, you couldn't turn it into a condo or anything. One accessory dwelling unit per single-family house. And then I list the types of accessory dwelling units, which are it could be entirely within the existing walls of the single-family residence, added as an addition, located partially within the single-family dwelling and partly as an addition, built as part of a new family residence from the get-go with a building permit, or located above a garage that's attached to an owner-occupied single-family residence. And then accessory, okay, so there are a lot of, yeah.
Before we move off of that one, I didn't think we specified that on the garage, that the garage had to be attached.
So here's what, I had spent a lot of time puzzling over this. And I think that's right. We can allow them detached, located above a garage to an owner-occupied single-family residence. But I think when it's detached, I thought there were two cases in which it was legitimate to ask the homeowner to get a special permit. And one was to put a unit above a detached garage, and the other one is to add a unit to a non-conforming lot. That's a judgment call, but it is definitely different. You know, it's separate plumbing attachments, it's separate sewage attachments, it's if the garage is detached. So we can come back. I'm going to identify that as one of the issues that we're going to talk about is the detached situation. But you can cross out attached, located above a garage to an owner-occupied single-family residence, and then we'll get back to that because I actually think I picked that up later. So anyway, and then the accessory, the 5 is the accessory dwelling unit can be added as of right, meaning it doesn't need a special permit if the lot on which the owner-occupied single-family house is located conforms to the dimensional regulations contained in Article 5, Section 5.1, and other applicable zoning laws. So if it's a conforming lot, you can do it. But then 6 is where I picked this up. A special permit is required to build an accessory dwelling unit on a lot that does not conform to the dimensional regulations. Everybody understands that, right? It's the 2 acres, 200 feet, the setbacks. And then it says, whether as part of new construction or as an addition. Meaning if you want to build a new house, like we approved not long ago, a lot that was just shy of the footage needed. So it would be as a non-conforming lot. If that, and it was just a single family house. But if that person wanted to build on a non-conforming lot that was grandfathered, they would have to get a special permit to add, because the idea is, it's a smaller lot and it needs to be careful consideration. And then I also put, and to build or add an accessory dwelling unit above a garage that is detached from a single family house. I personally feel that's a different category if it's detached. You're not part, you don't have that common law, you're not really part of that family. And a lot of things go into that decision. That's a judgment call. Come back and we'll visit. I'm just walking you through the structure I put in it. So no special permit required unless the dwelling unit's above a detached garage or on a non-conforming lot. That's a big change from the present bylaw, which requires every accessory dwelling unit except an in-law to have a special permit. Okay.
Madam Chair, quick question.
Yeah.
So item number 4 basically would, and I'm harping on the garage because it does apply in my particular case. But my question here is that would be on an existing lot, an existing unit, on an existing garage, whereas 6 is very specific to building a new accessory dwelling unit, correct? And as is number 5.
Yes, actually, E, take out the attached because Christopher is right. But anything that exists already is grandfathered. It only takes, this will only affect.
Correct.
For things built afterward, but it would be if you wanted to build, like there's a new one of the Ragged Hill lots that is being built has an accessory dwelling unit over the 3-bay garage, right? And it was permitted as of right because they permitted it as a in-law. It is in fact an in-law. It's going to occupy it initially anyway, right? But I think if they were going to say, okay, we're going to build, I mean, garages are bigger than houses these days, right? So if somebody wants to build a 5-bay garage and put a giant apartment over it, I think, I don't know. I have limited apartment size, and that is one of the other issues we have to discuss. So I'm in favor of, as we say, pondering on this, but moving ahead. I'm just giving you the structure I have, and then we'll come back, okay? So then B is, but that's the way I've written it, and we can change it. The size and occupancy restrictions. This also, we went back and forth, and I've lost, I don't know, my notes were confusing. We don't have minutes. So if it's, I'm trying to do the best I can with my recollection, which isn't great. So this says the living area of an accessory dwelling unit can be no larger than 50% of the living area contained in the single family residence to which it is attached, or 1,000 square feet, whichever is less. And it may have no more than 2 bedrooms. So this is something we can discuss this here if you want, rather than, I don't know what that magic number is. Rutland, in a lot of towns, just say it can't exceed 1,000 square feet, that's it. But if you had, would you allow an accessory dwelling unit of 1,000 square feet to be put on a house that is 1,000 square feet, to actually double it? Maybe. So I'm interested in what people want to do with that. And do you think 50% is too small? Like if you had 1,000 square foot, if you had a 2,000 square foot house, you could put 1,000 square feet on, but if maybe you had a 3,000 square foot house, you want to go higher than that. I do think 1,000 square feet is enough to put 2 bedrooms, kitchen, bath, and small living area. And it is a standard that I didn't pull out of the air. It's pretty common for towns that limit it.
Madam Chair, listening to you talk about it, the 1,000 square feet makes a lot of sense to me. I didn't even think of a scenario where maybe you have somebody who has a house that's smaller than, well, really, I guess if it was smaller than 2,000 square feet, it'd be putting a limit smaller than that on it. And if you had a house that was around 1,000 square feet, it would be pushing it down to 500. Yeah, I'm not sure that you necessarily end up with a great result there. The 1,000 sounds great, though.
Is there,
Um,
that would be fine with me. What do other people think? Should we skip the 50 and put can't exceed 1,000?
I think that makes a nice, I would agree with that. I think that is a very good compromise here.
Okay, I'm marking it out. So it would read, can be no larger than 1,000 square feet. And no, and just, that's what Rutland did.
1,000 square feet and then no more than 2 bedrooms.
No more than
So,
2 bedrooms. Okay,
okay.
okay, so we've got that. All right. All right, and then the accessory dwelling unit cannot be occupied by, I know Bill, who's not here tonight, defend his position by not more than 4 people. I think you gotta have some kind of limit on it, 1,000 square feet. And that's common, the 4 people, and that is what is in our bylaw right now, accessory dwelling units. So he says, well, what if I have my grandkids over and I have 6 grandkids? And it's like, you know, it's kind of like the Airbnb issue too. You're gonna have people that are gonna undercut it no matter what you say, it seems to me, but does 4 seem like a reasonable number? Or is there really an objection where you think I shouldn't put a number in? Anybody?
Well, Bill just turned the camera on, so I was waiting to see if he was going to comment before I said anything.
Really?
So Title V, which is the state sanitary code, assumes that you can have no more than 2 people in a bedroom. So what you've done is you will have no more than 2 bedrooms and you will have no more than 4 people. So you're backed up by another regulation. I think you should leave it in,
Great.
but it toenails really well.
Okay, let's leave it in and move on because we're never going to get through this. All right, the owner of a single family resident must, okay, this was this issue that Whitney was talking about. Maybe it isn't worded so it's, you know, you try really hard to word these things. Here's what I've said. The owner of the single family residence, so that's the title holder of the land and the residence, right? The owner of the single family residence must reside in either the single family residence or in the accessory dwelling unit. And for at least 5 months a year, we talked about this. And the single family residence and the accessory dwelling unit may not both be rented or leased to two tenants on a year-round basis. I should probably say at the same time. I don't know, but that what my idea was, we want to save the notion that the owner has to occupy one unit or the other. And then we had gone into this issue of, well, what's a reasonable requirement to have them live there? So if you had, for example, the family that's moved into the house and the senior that moves it, that owns the place still living in the in-law, and she wants to go to Florida most of the year, you know, that would be okay. But the resident requirement shouldn't be just 30 days a year or something. So this is something we specifically talked about. Our feelings on that?
So, Madam Chair, I really like the idea behind it. I don't think the wording is super confusing. I don't want to blend the issue too much with the next one, but spent a bunch of time doing research trying to look at how people have looked at how this impacts housing and specifically affordable housing. And it seems like where you really hit the slope is when if you set something up that leads to just purely commercial ownership for the purpose of doing short-term rentals. And this number 3 right here would prevent that, because it would eliminate the likelihood that somebody would just be buying a property to stick a unit on to rent them both out, and turning it into a really what would be a multi-family rental, even if it wasn't even a short-term one. So I really like that as a backstop to that issue.
But may I ask a quick question? If I just read just the first sentence by itself, that precludes the second sentence from ever happening. Would it not? If you are requiring that the residents be there for at least 5 months per year, that means there for I mean, for me, that's logically indicates that you cannot have both the primary and the accessory dwelling unit be rented
You're right.
simultaneously.
Yeah.
So your first sentence basically covers everything. I don't know if the second sentence adds any value here.
I think Francois got a good point. What do you think?
No, but you could have somebody renting it out for the remaining, both units being short-term rental for the remaining portion of the year, the 7 months of the year. So you could
Correct.
have that scenario.
That is true, but here it precludes it for year-round basis.
Mhm.
Yeah, because even without that second sentence, it's still going to preclude it.
Exactly.
All right, so we should
Odd
strike
to
the
you,
second sentence?
I mean, I don't get me wrong, you can leave it in there. It's belts and suspenders in my opinion, but your belt is pretty well established.
I like to make it clear, and if it's very clear from the first sentence, you don't need a second sentence. Okay, so then we go on, the lease or rental of now we're not talking about the lease of the house because this is an accessory dwelling unit by law. We're just talking about the accessory dwelling unit, right? So this is where the rubber hits the road on the, are you gonna allow the Airbnbs?
So
I thought it was kind of a quid pro quo if you told the town, well, you're not gonna need special permits to get these and you're gonna allow anybody to be there, that this would be a safeguard that make sure it wasn't just a revolving door. But I do hear what they're saying. And I know they're very passionate about it, Katie and Whitney as well.
Madam Chair, I think this is a place where it's kind of important to look at the bigger context, because really, if we were to strike that, what we wouldn't be doing would be allowing Airbnbs and all those to operate. That's really a bigger policy issue for the select board to take on and to regulate. All we would be doing is we would be eliminating something that would be a potential roadblock for them doing it down the road. Because
Suggest
well,
striking
I would suggest striking that sentence and letting the select board make the policy issue, because even looking at it from an affordable housing standpoint, the way cities and towns have tried to balance that is by doing a transient occupancy tax. And I know there are some examples from Western states, and I'm not sure if we can do them here because of the financial laws in Massachusetts, where they use part of the transient occupancy tax for funding an affordable housing trust fund for developing.
Okay.
Yeah, and there's all kinds of stuff like that can be done, but none of that stuff that the planning board can do. All we can do is look at that one zoning issue. And I almost get nervous when people get too far ahead on like, well, we can do this and this and this. It's like, we can't do any of those things. All we can do is not put up this barrier and let the select board decide what they want to do with it.
Okay, so Chris, next question, but just, and then I'll hear you, Francois.
Yeah, sure.
So in my definition, where I say, list the people that can occupy it, occupants may include, the last thing is, or tenants, right? Occupants may include dependents and guests of owners, caregivers, nannies, and other service providers to owners and tenants. I don't know whether that should be and or I know it's a grammatical problem, but would tenants include Airbnb people? Are they considered tenants?
I believe they are.
Yes, they are.
Okay.
Tenancy in years doesn't have to be for years, so.
Okay. Okay, now Francois' question.
I forgot what it was.
I'm sorry.
No, that's all right. If it comes back, I'll blurt it out.
I just don't want to cross out something and create, and that leaves us with just that one word, tenants are allowed, just tenant. I just want to make sure it covered these
Oh,
people.
no, now I remember. I'm sorry, go ahead. I'll remember it next time. Go ahead.
Okay, so I'm gonna, for the moment, and there's a working document, scratch 4. So we have.
If I may, because this is related to number 4, are we suggesting that if we are leaving this here to the, so it's not something that we're going to take on as a planning board and therefore it becomes part of the zoning bylaw. If this becomes part of the selectmen's making a decision, where would they put this? This is in the general bylaws? Or
I
are they
think
gonna, or are they, and the reason I'm asking is, are they gonna come back and say, well, no, this is a matter that really needs to come in from a zoning perspective, and therefore it has to go into the zoning bylaw?
I
I
think
just want to
you're,
make sure we're not ping-ponging this back and forth with the select board.
The
Okay.
select board has the authority to, if I may, Alice, the select board has the authority to tax and specify licensure requirements for businesses.
we
They're the
don't.
business and licensing
No,
authority.
that is correct, but as to whether or not they are restricting it is what I had heard earlier. Maybe I misunderstood then.
They could have a general bylaw requiring registration for someone to operate a short-term rental in the town and use that as a basis for establishing the fees.
Okay, but in terms of being able to set the time limits, in terms of like for what we are saying here, which is that term not less than 30 days. Is that something that can be prescribed by the select board?
I'm sorry, is the question whether or not the select board can just prevent them from operating in general?
No, not in general.
don't
but
understand
just-
the question,
No,
I'm
no.
sorry.
So here we're making a very specific restriction. The restriction is the term of the lease may not be, not be less than 30 days, right?
But we're striking that.
No, I know that, but we're also saying that it is up to the select board to make that decision, A, as to whether or not they are going to be putting some form of restrictions. And is that certainly something that they can do using their powers and the general bylaw? This was specifically added, Alice, I thought, just to make sure that we don't have anything less than 30 days.
Yeah, I think this is a real existential debate here, you
Mhm.
know?
And I know
Uh,
that the town people, the people who I've spoken with in town here, have commented that Airbnb, which, you know, you can have a daily rental, you can have weekend rentals, you can have a 1-week rental, etc. There's a lot of opposition to that.
Yeah, and that's
And
why I
I'm-
told Katie, I said, I can strike it for you and leave it out, but it will probably sink the bylaw because I'm not
Okay.
sure we'll get 2/3
Okay.
support.
Yeah.
And I said, but if we don't strike it and we leave the 30 days in, I don't think we're going to have the support of the select board among other
Mhm.
people because
Okay.
they're passionate about it. So I think either way, we run a risk of, not having the vote. And I don't know how the town feels. I mean, I'm an old fashioned person. I would put it in there. That's why I put it in there, because I wouldn't want my neighbors to have somebody else all the time.
Well, I'm here in California and we have problems. I'm seeing it right here. They have party houses.
But what Katie, yeah, exactly. But this is the owner next door at least 5 months a year, right? But what Katie said is, and this did cross my mind too, is when I looked at the Rutland bylaw, which is a much more complicated bylaw, we have 2-acre minimum lots with 200 feet of frontage, right? So these are not like in-law apartments that are 10 feet from the neighbor. And you can't add one to a non-conforming house on a smaller lot unless you get a special permit to do it. So you could on the special permit say, okay, I would think, I have to ask Bill, I guess. Yes, we're going to allow you to have, to do the in-law apartment for your elderly mother, but because you live on a 1/2-acre lot, we're going to, part of your special permit is going to be, you can't do short-term rentals. I don't know, Bill, I can maybe weigh in on that, but other than that, I don't know how to resolve this. I mean, it's either you put a restriction in, which was going to preclude, even if it's like 5 days, it's going to preclude almost all Airbnb and short-term rentals, or you leave it out and the doors open for them. What Katie said to me was, this is going to be, the town, we're not going to be, it's not a destination place. So if you put your in-law apartment on an Airbnb 365 days a year, you're not likely to, fill it with short-term rentals 365 days a year. Whether you buy that logic, that was her logic. And if you did have like this wedding venue come in or some destination, people might want to come out and rent it for, a few nights for a wedding, and it would allow people to make a little bit of money off their in-law apartments, and maybe the town too. I mean, out of their accessory apartments. I don't know. I mean, I think it's up to the board to decide. I could go either way on it.
I think it's important to remember we're requiring owner occupancy of either the ADU or the primary residence itself. So that itself will mitigate what you see, and I know California and some ski places you see issues with it, where you do end up with a party house, but that's usually somebody renting an entire house that's in a neighborhood, not an ADU or not a house that's in the same lot as the person that owns it.
Christopher, I think you make a very convincing point, and I would agree with you that that is indeed a mitigating factor. So seeing it from that point of view, I would tend to agree. I still, however, think that the town itself may frown on this here.
It may sink the
The
ship.
mentality. It may
Yeah.
sink the ship, and we just need to be conscious of this here. So you may have I'm just saying, you may have an excellent bylaw amendment here that may just go down because of this one. Well,
that's why I'm afraid of this becoming as much about short-term rentals as it is, because what we're doing, it's not it's not making short-term rentals all of a sudden okay in Hubbardston, where that becomes a business that you can do. Like there's a lot of things that have to happen for that to happen. All this is just one of those roadblocks along the way. So us presenting this with number 4 struck out of it still means that, well, licensing requirements, all of that stuff still has to happen. And that isn't a small thing on its own. And that's why I get a little, and I kind of cringe with well, this is going to allow Airbnb. It's like, well, it's one of the steps along the way. And really it's the step that allows the select board to do it if they potentially do. With that said, sometimes, yeah, that could be the lightning rod. Somebody could come up and be like, well, no, this is going to allow Airbnb everywhere. It's like, yeah, along with 3 or 4 other changes that have to happen in town for that to happen. Yes, this is something that could be a contributing factor to it, but it's not opening the door on its own independently.
I tend to agree with you. My only concern again is you have a very experienced view on this here, and you've done this here in depth. Individuals who typically come to the town meeting have not necessarily had the benefit of the experience that you have, nor have potentially researched it. We would have to make sure that this gets an education process take place, and even that is, I think, a very hard. I'm just very, very concerned that a very good bylaw might be sunk just because of this one change. I wholeheartedly agree with what you're saying, Christopher. I'm just concerned that the mentality of some individuals is going to be very much swayed by the fact that this really is perceived as an opening of a short-term rental.
You know, if it fails, you can run it in the fall with the line back in it.
You're absolutely right. That
Yeah.
is absolutely. We just need to be conscious of this here as a select board. I'm sorry, as a planning board, and that the select board themselves also need to be conscious on how this gets presented.
Yeah, and I think that this should not be the first front and center. Katie thinks nobody will even raise it. I said, Katie, you're dreaming. This is going to be raised on the town hall
Big
floor.
time, big time, big time.
It just got raised because we just spent 25 minutes talking about it and people watch our meetings.
Oh yeah.
This is now an issue.
But there was no way it wasn't going to be an
Yeah.
issue, in my opinion. But I do think that, which is the truth, is that what we are trying to do with this bylaw is not trying to liberalize it on this point. What we're trying to do is make a bylaw that's coherent and that provides better housing options, and that actually allows people to add a unit, which helps the housing situation, right? And if that's units being built for their nanny or their caretaker, you know, get rid of the relative requirement and don't require 2 acres and 200 feet of frontage is enough to add 1,000 square unit, right? You don't, or the accessory dwelling unit, you shouldn't put everybody through the special permit, you know. So we need to explain it.
Yeah, I do like the suggestion see if it happens, and if it draws objection, re-present it with the restriction added to it, if that's really what the voters end up wanting.
I mean, could this be presented, and then if such objections come to play, and instead of it being sunk, that as a friendly amendment at the
Oh.
town meeting itself?
No, you can't
That-
do.
It's substantive. I'm just trying to understand the gradient of
Yeah.
change here.
Yeah, the moderator ultimately has the decision on that. And in the past, the moderator's been pretty strict with what he's considered to be substantive. I don't know if it changes if the
Yeah.
board also supports the modification.
I-
But there's a public notice element to it, so.
I would agree. Okay, no, it was just a thought, and I do agree that we have an out, which is basically the fall meeting.
Right, and we need to carefully present this. I mean, you need to also just be a little logical about it, like Katie was. It's like, you're not gonna make an income through Airbnb rentals on an in-law apartment in Hubbardston. You know, you're not gonna have you might make a little income, but it's not gonna be a 365-day thing. And somebody's probably not gonna put $100,000 onto an addition just so they can Airbnb it, because the investment isn't there, you know, the revenue stream. Anyway, she made some sense to me. We will go with leaving it out. Let's go on, because we're it's just an impossible agenda tonight. All right, so architectural and aesthetic requirements. This is out of the Rutland Bylaw, but I think other ones too. Accessory dwelling units must be constructed in such a way that the entire structure maintains the appearance of a single family residence. All right, so you can't dictate architecture too much, but this does say to people, you retain the front door, and then you add the other door as a side door or as a recessed front. A lot of houses have two doors, but you have a main entry. You try to match the sidings. So that's a kind of a general phrase, but it covers a lot of things, I think, and I think it's worth putting in. Our bylaws have nothing of the sort. And then 2 would be accessory dwelling units must be attached to the owner occupied single family residence through a common wall. So you can't just have a breezeway between two 1,000 square foot buildings. And that was also common. It was in Rutland, and it's in many, that it actually has to be attached. And then the exterior stairways to a second floor accessory dwelling unit must be located on the side or back of the structure. Remember, we talked about whether it had to be inside, and we struck that, and I think that's right. But it should be on the side or the back and not running down the front of the structure. Anybody have an objection to any of those 3? Architectural, aesthetic. All right, moving on. I also got an objection on number 2 from Katie on this one, is driveway. So the first one, these are parking, driveway, and septic requirements. The owner occupied single family residence in accessory dwelling units must be served by the same driveway. This prevents people from putting a whole nother driveway on the property, right? And then we talked about these off-street parking, and I had written, which is what's written here, that 2 additional off-street parking spaces must be provided for the accessory dwelling unit and cannot be located in front yard or on the driveway. So, I mean, we can leave it as it is. Katie's objection was, why can't you park on the driveway? And I said, because you cannot, if the accessory owner of the accessory unit's away and they're blocking the driveway, you can't get emergency vehicles in and out, right? So it's got to be off the driveway. She thinks it could be better worded, so I'm open to ideas. I'm open to maybe it doesn't have to be 2 additional parking spaces, but that does seem reason, because a lot of these dwelling units do only have 1 person. And I think we could put in that they do not need to be paved. She also thinks that they should be allowed in the front yard, because a lot of houses have driveways in the front and people park in the front and they're set, 100 feet off the road. So I'm looking for ideas on rewording that. And then the third is just that the septic system has to be correctly sized for both, which it would have to be, but it needs to be added to tell people, I think. So thoughts on the driveway?
So on the driveway, I echo the concern about the front yard because we do have very large lots and decent percentage of properties, the parking is in front of the house. My house, the parking is in front, the regular parking is in front of the house, but I have a 300-foot long driveway.
Right, exactly.
And that's not uncommon in town. So to have people who park in places that probably aren't even visible from the street, not be able to just expand that driveway a little bit more or put a couple spots off of the driveway, it seems like the front yard is an unnecessary requirement given the size of the minimum lot size that we have in town.
We could say, and I'm not saying do this, I'm just a suggestion. And the parking spaces should not be in the front yard setback. What is our setback? 75 feet, right?
Right.
I mean, you do see all over town where people have, not our town so much, but towns in general, where people have paved the front yard for parking, right? And that's the look we're trying to get away from. So think of a way to say it because it's our last hurdle here.
That is a good idea. Because that is ultimately what people are going to be concerned about. They're going to be concerned about thinking about like the lots that are in the town center. Be like, just stick another apartment on and pave the front yard and call it good. But if you were to do it as within the setback requirement, I think it alleviates that in a way where, well, when you have these larger lots and there aren't those same physical limitations and it makes sense, you should be able to do it.
Okay, all right, so I'm going to rewrite this to say, now, you think the 2 is, I actually think the 2 is reasonable because even if you have the senior citizen there that's living there, right? They do have people, their car is going to be parked there, you know, all week, every day, right? But they're still going to have people visiting and bringing groceries and stuff. I mean, I don't know, think about it, but so there's a lot of components to this, but if I reword it, leave the 2 for the moment. 2 additional off-street parking spaces must be provided for the accessory dwelling unit and cannot block the driveway or be located within the front yard setback. And then I can put in parentheses what that is. I think it's 75 feet from house.
That's, doesn't it change by the zoning district?
No, I don't think so.
Well, the downtown district, I don't think they have.
Yeah, okay. Well, if I say front yard setback, people will know what that means. I guess they would.
Yeah. Well, it's defined in the zoning bylaw.
All right, I could put the reference there again. 5 point whatever.
I was going to suggest on the driveway shall not be located in the access portion of the driveway.
Instead of cannot block the driveway, cannot be
Well,
located. Cannot, say it again.
Cannot be located in the access portion of the driveway. I don't know if that's clear, but. So as to block the driveway.
Okay, so if you had a driveway that was 2 lanes wide, which some are, right? They could do it.
Yeah, because you always want the fire truck to be able to get up there. Or an ambulance or whatever.
Okay.
Or maybe you say.
Cannot block emergence. All right, I'll work on it.
How about if we do it in the affirmative and say must maintain access to the structure for emergency services, as opposed to restrict. But then if they have a U-shaped driveway, they're going to claim part of the U as parking.
Well, 2 additional off-street parking spaces must be provided for the accessory dwelling unit and cannot be located in the front yard or
Setback.
I don't know, what do you, I don't know. You know, it's not like I didn't scratch my head about over every single word of writing this. You have no idea the number of hours I put in it. It's just tedious work. But we can do the setback and we can do cannot be located in the driveway in such a way that it would impede emergency vehicles.
Right.
Okay, or something like that. All right, so if I do that, if I make these changes, are we all, I don't really want to run through them all again because I think we've been very careful with them. But if I make these changes, do we have a draft and I'll send it out, that we can advertise for public hearing on the 24th of February? What do you think, guys? And then I can distribute to the select board and so forth.
Alice, can I suggest a change to the last one, number 3?
Yep.
The septic system and well must be correctly sized to serve.
Yes. Okay. Okay. So I have those. I'll fix it up tomorrow. Send it all out to you for one last look. Send anything you object to, right? Take a look at it. And otherwise I'm gonna, does anybody have a problem with the February 24th with bumping that meeting a week? Poor Mallory, she's got to be in the hospital with her kid who's having a spinal surgery. So, I don't know, maybe Mallory didn't want me to say that. I don't know. Anyway.
Totally fine.
Okay, but she thinks that the 24th she'd be back, and I think she's right. You know,
Yeah.
it's a critical period, but then she'll be recovered enough to be back. So can we all do that and have our hearing that date instead? Anybody object? In our next meeting?
So this will be the 24th of February.
Yeah, it won't be the next meeting. It'll be 2 meetings. Because I don't think we can get it the first week in February. There's not enough time. Is there, Mallory? You know, you got to advertise it. You got to get the papers deadlines and.
Yeah. No, I don't think so.
Okay. All right. Public hearing 24th of February with these corrections. And thanks very much. Okay, so sadly, that's not the end of our meeting and it's very late. One good thing is, you know, on the 20th, the next meeting, for better or worse, we're doing that new rate of development bylaw because it's been published and that's the way it is. And if people are going to give us a lot of flack, we can change it, but that's done. So then the other bylaw that's just right hot off the press came in, what, last night or night before last, is the battery energy storage system bylaw changes. And we could have that hearing on the 24th too. But does Bill want to address some of those changes? I have a couple of questions about it, but go ahead and tell us how this worked out when you sent it to your expert.
My expert didn't have very many changes. What I asked him to do was look at it just from a very technical perspective and tell me if there are any fatal flaws. We're saying something that can't physically be built, or we're citing something in an incorrect manner, or something that violates the code. And he said, no, it reads easily, and he had very minor and extremely specific citation references. I don't know, he had maybe a dozen changes total. So that they were not included in my review, but they're pretty straightforward. I don't see anything that that the electrical engineer gave me that's really subject to debate or discussion. Francois, did you get a chance to look at that?
I'm looking at it and I just want to confirm that the changes that were made are the ones that are highlighted in the document, correct?
In yellow, yeah.
Correct, highlighted in yellow, correct. No, absolutely not. I mean, I see some changes where it's primarily making references to the NFPA 70-2020 articles. There's a lot of items there, which is great. You also indicate that there's amendments now to the Massachusetts Electrical Code. So you're expanding on that. There is something about, let me see, section, well, item 6, and then there's the exterior lighting and screening vegetation or structures. I think it was just added with related photometric plan, correct? So that was the only thing that was just added there.
Right.
Then you also added short circuit current ratings and amperage interrupting capacity ratings. So those would be added. No objections to that at all.
It's really technical stuff
Now,
that the electrical did.
that absolutely no. I see no issues, and I'm assuming again that you concur with everything here.
I can't, well, that's why we hired this guy, because this is not my area of expertise, so I can't.
Okay. Now, one question I have is the very, very top. It says large scale battery energy storage systems, ESS. So he made a change. He took the B out.
Yeah, I don't know why.
Okay. I mean, I've always known it as BESS, battery energy storage systems, and leaving it generic as energy storage systems. I'm kind of, that would be my only question. What was there a particular reason why he took out the word battery, or I'm sorry, the abbreviation for battery? Other than that,
I'm just wondering if they're going to stop calling them batteries in the near future with different technologies, and by removing the word battery.
Okay, if you can just get the clarification on that, I have no problem. I just want to make sure that, you know, that the industry standard is followed. That is all. But great job. I really appreciate not only that this was done, but it was done in a short time, in the short time that we had.
But you did see my edits, did you not?
I'm looking at those. Those are the ones that you have
highlighted
in red.
Yeah.
Okay. You know what? If for the benefit of
I turned track changes on that one.
let me share my screen. Mallory, can you make me presenter briefly so I can, and that way everybody can see what I'm seeing. Thank you very much. Let me see if I have it now. Oh, okay. Yes, it's my desktop share. Yep. I'm gonna share my desktop. Can you see my my screen now?
Yep.
All right. So I'm just going to go down briefly. These are the highlighted sections.
That's from the electrical engineer.
Yeah. I see design standards. What you've included here is including without limitation any poles with new.
No, you don't have my full changes.
Well, this is what is on the SharePoint site.
Okay.
There were two documents that were sent as attachments, and I think they were both posted, right, Mallory?
Yeah, they should have both been there.
I think they were both. I thought they were in different formats or different.
Well, exactly. One is a PDF file, and this is the Word file, right?
Yeah, there's a version that was emailed before the meeting. I think that's the one that has the.
Right. Bill, would you
red marks
kindly?
commenting.
I can relinquish the sharing here if you could bring it up because I do not have yet access to that right now, or it would. I mean, I could get access, but it's just.
Bill, the one I have has like the severability clause crossed out. Is that the latest?
Actually, mine's still in Word. There it is.
Right.
Yep.
So
Anybody see that?
No, not yet. I guess I'm.
Yeah, you gotta make him the host, Francois.
Oh gosh. So what do I need to do here? You've made
Or
me
you can
all
give it back to
powerful.
me.
Wait,
How do I
click.
Here, I can reclaim myself as host and make Bill host.
There you go. Thanks, Bill.
Oh shoot, I just made Chris.
It's getting late too, folks, so. Somebody.
Yeah,
can-
and I got a lot of comments in here that you all may want to not
Okay.
look at tonight.
Okay, so Bill, send that so we have it all. And then I have one question I want to ask you, which is, I don't think the way this is written about the setbacks makes it clear about that the fence can't go, a 7-foot fence can't go right on that property line. So that has to be clarified.
7-foot fence can. go on a property, and an 8-foot fence cannot, it's considered.
Yeah, I
a
know,
structure.
but I don't want to set this up like we did with the marijuana, where some neighbor, the whole unit is set back this great distance and is, hardly visible, but this 7-foot fence is right on the property line. Okay, so can you fix that?
I
Where
think
you're
I
asking-
have that covered,
Where? I didn't see it. Maybe you fixed it,
way at the very end.
and maybe you fixed it in your fixes that we didn't get.
Yeah, I don't think I see the fixes.
Send it again and we'll just put it on for it's really late. And I want to get on, there's 2 things I have to still do. One of which is we have to approve Bill's invoices. And the
I'll
other.
stop talking then.
Yeah, well, we'll just put it on as one of the first things next time, after the hearing, right? We'll put this on. Okay, Mallory, can you do that?
Sure.
Remember that? But we do have one other thing, which is that we've had a request from the town administrator to meet with them concerning the enforcement officer, the zoning enforcement officer. That came in fairly late. Mallory, what's the latest on that? I'm like,
There's a February 7th select board meeting. Joint
where they
meeting.
okay, where they want to talk about the zoning enforcement officer situation. And they've asked the planning board to attend. That'd be a Monday, right? One of their Monday meetings. Can people come to that? We can post it anyway, and if we don't get a quorum, the people that are there can just stay and participate.
Is this
Right.
this coming Monday?
No, February 7th, it's a month away.
February 7th, I need to RSVP, so
It's like 5 weeks away.
Boy,
you want to mark it in your calendars and I'll tell them, yes, we'll try to come.
time?
Okay, so I would do that. Mallory, you can do that tomorrow. Or not tomorrow, but next week.
Sorry, what
then-
time? At what time on the 7th?
6:30 is
meeting-
their meeting.
And they did say they'd put us I'm sure if we show up in mass, they'll put us first, generally. I'm beyond a few announcements. All right, so the other thing is, I think, let's make sure. Yeah, I don't have a lot on the housing front. CPA, we're working away on that. I don't think there's anything else. So let's make a vote or discuss if we need to, paying places invoices, which were on the documents.
I make a motion that we pay the invoices.
Anybody want to discuss? One is for, one is kind of a miscellaneous bill of stuff we've sent to him, but they included things like the Gardner Road meeting that we asked, or the 28 Gardner Road. Is that it? Catasto, that meeting, things that we really did ask him to come and attend. And the other one, the bigger one, is for, let's see. Oh, Healdville and the Ragged Hill, that enforcement. And the Ragged Hill was the funny trees that leaned either way. So, okay, so there's a motion to approve these 2 invoices. One is for $973.25. And the other one is for $384. Motion's been made. Is there a second?
I'll second Christopher.
Any discussion? Okay, hearing none, we can vote. Lived all eye.
Amelia, aye.
Monroe, I.
Tiger eye.
Oh, you guys are great.
I know there's something I'm forgetting. And this is my agenda. It's like completely covered in red ink. I don't know what it is. Okay, so our next, I don't know. I'll have to send you a text tomorrow or something. Oh, I know what it was, is Bill, we got a note that I haven't forwarded to you about, I think it's the storage unit lockers, the storage lockers people.
Yes.
they're waiting to go. Did you get a copy of that?
I did, yep.
Okay, all right, so are we okay with that? That's in your, I mean,
I just got it, I think, yesterday or today.
Yeah, it
barely got a
literally
chance
came in
to
at
look at it.
4 today, so.
okay, so if you need to get more money for that part of the project, you know?
I did
yeah,
give them,
fine.
I gave them a value, I'm pretty sure.
That included it, okay, I'm just asking you to be aware of the funds, because that's something.
Well, what I'll
Okay.
do is I'll find it and I'll send it again to Mallory and to them.
Okay,
I'm
all
pretty sure
right,
they have it, yeah.
okay, I think that's it, guys. Anyone want to make a motion to adjourn?
I will make a motion to adjourn.
I
Second,
the motion.
all in favor? Lived all eye?
Tiger eye.
Mealy, aye.
Monroe, I.
Okay, we stand adjourned, guys. Thanks very much for sticking it out so late.